Good afternoon, everyone. Not sure if everyone can hear me. A little thumbs up. Great. Welcome to the somewhat regular now update from Scholz Nonprofit Law. And I'm not Melissa, in case you noticed. My name is Jessica Harrison, and I'm subbing in for Melissa this week. So I'll play the role of moderator. And I think many of you are familiar with our format, but Jeff will give some updates, Sarah will give some updates, and we have several questions that you all sent in beforehand, so thank you for those. If you have any questions that come up during the discussion, just use the chat feature and we'll try to get to those. And if you have a really burning question that we don't get to, then you can please contact either Jeff or Sarah by email, and they'd be happy to either set up a time to talk or just email if that's easier. So same format as usual. And we wanted to thank the Madison Community Foundation for their continuing support of you all, which is really important to us. So thank you to them. And also wanted to remind you that we have a pretty robust question and answer section on our website. So after each of these sessions, we go back and update that again. So it's pretty current and I think a pretty good resource. Just wanted to remind you about that. Any other housekeeping business? I don't think so. So today we'll start with Jeff, who's going to talk about some updates to the PPP program and specifically how to make sure your loans are forgiven. And then after Jeff, we'll switch over to Sarah, who will talk about some nuts and bolts about how to reopen the workplace. So with that, I will turn it over to you, Jeff.
Thank you, Jessica. Somewhat different than some of these presentations in the past. I have a lot more information. Almost all of it is good for you. There have been some rather extraordinary movement in the PPP program in the last couple of days. Some of which isn't finalized, some of which is, but I'm going to go through that. Then I'm going to address some of the questions that were sent in advance, and then we'll see if you guys have any questions after that. So the first news is that on Friday, the House of Representatives passed what is called the Paycheck Protection Program Flexibility Act. Both the House and the Senate had bills moving through that we've kind of anticipated. They're in recognition of the fact that, you know, this PPP is not really working out exactly the way that the SBA or the Treasury Department intended it, and that some flexibility would benefit the borrowers. So anyways, this thing passed the House on Friday afternoon, bipartisan. I think it was 417 to 1. So you can tell that people are hearing from representatives are hearing from their constituents. And then yesterday, Senate Majority Leader McConnell and Senator Rubio is the chair of the Small Business Administration Committee. They both indicated that the Senate would be abandoning its own bill and moving forward on the House bill, which leads me to believe that they're going to move on this pretty quickly. So the PPP Flexibility Act provides two things, both of which are good for us borrowers. And that is, first of all, it extends the covered period. We were anticipating that, and it does in fact do it. It extends that 8-week covered period to either 16 weeks, or if you get your PPP loan funded late in the year, it has to be, you know, the end date would be December 31st. But as a practical matter, for those of us who've already received our financing, you now have 8 weeks or 16 weeks instead of the 8 weeks to do your forgiveness calculations. So that is obviously good news. And presumably, the legislation doesn't actually say this, but presumably there will be some sort of mechanism for those of you who are bumping up against that 8 weeks right now. There'll be some sort of mechanism to amend your loan forgiveness application. So anyways, that's good news. The second component of the Flexibility Act is it reduces the requirement that 75% of loan proceeds be spent on payroll costs. There was a recognition that all borrowers are not in the same situation. And while they certainly do want to encourage borrowers to use the funds for payroll costs and put people back to work, the determination was a 75% was a bit steep. So that has been adjusted downwards to 60%. So now you are allowed to have 60% payroll costs and then the other 40% on other eligible expenses and still be able to get your full loan forgiveness. So that is good news. Does anyone have any questions about that at this point? Just like watch the news. This thing, you know, I mean, there's obviously other things are, I quite frankly missed it on the news because other things are going on that are taking up the broadcast space. But, you know, I can't imagine this thing doesn't pass in the next couple of days and land on the president's desk. So, okay, the second piece of good news is that we finally have some official guidance, some more official guidance from our friends at SBA and Treasury on what exactly some of these terms mean for the purposes of calculating our loan forgiveness. And virtually all of it is good. And if I had to describe a theme, the theme is that lenders and the SBA are going to interpret expenditures by borrowers loosely, liberally. They're not going to have a tight control on it. And you'll see what that means when we get into this a little bit. So first of all, we finally have, and I think I mentioned a month ago, you know, what exactly does this incurred and paid mean? And now we finally have specific guidance that said that the SBA has said that payroll costs eligible for forgiveness include payroll costs that are paid during the covered period and payroll costs that are incurred during the covered period. Specifically, what that means is that amounts paid during the covered period, or if you elect to use the alternative covered period, even if it relates to an earlier period, if it's paid during the covered period, it's going to qualify for forgiveness. In addition to that, amounts incurred during the covered period, or during the alternative covered period, depending on which one you choose, but paid after the covered period will also qualify for forgiveness as long as they are paid on or before your next payroll date. So theoretically, you could put more, assuming we stick with 8 weeks, theoretically, you could put more than 8 weeks worth of payroll into your forgiveness calculation. Because if you elect to use the alternative payroll cost calculation, you get the 8 week, if you recall from last week, the alternative payroll cost is you elect to start your payroll calculation covered period on the first payroll cycle after loan funding. That gives you 4 full cycles. What this is saying is that anything incurred before that but paid during that period, or incurred during that period and paid later, you would also be able to include that. So theoretically, the way you play it, you might be able to extend that. So that is good news. And if we extend this thing out for 16 weeks, it becomes better news and certainly will help people more easily attain 100% loan forgiveness.
Jeff, before you move on, I already have a question in the chat. I think it's going back to the 8 week period, but the question is this: my 8 weeks would have been up on the 11th. My pay period ends on the 15th. Should I pay employees on the 11th, or can I wait until the 15th? And perhaps that's moot because of the extension.
Yep.
Okay. The second question.
Well, no, but you can absolutely pay after the date and count the entire payroll period.
Okay.
I
And
think that's pretty clear now.
right. And then do we have to use all 16 weeks if we don't stay at the 8 weeks?
Ask me that question again.
Do we have to use all 16 weeks if we don't stay at the 8 weeks? And maybe this is from Sarah. Maybe she's on the phone, so maybe she could type in some more context if you need that.
Yeah. Well, I think right now the defined term in the regulations and on the PPP application are covered period. So as of today, Wednesday, the covered period is an 8-week period.
Mhm.
If the Senate passes and the president signs this Flexibility Act, that covered period will go to 16 weeks. The concept will remain the same. It'll just be a longer period of time to use it.
Mhm. Makes sense. Thank you.
Okay. Okay. The second new provision that came out in the regulations talks about, and we've had a number of questions on this, talks about wages paid to furloughed employees, payments of bonuses, or payments of hazard pay. Are those types of payments eligible for loan forgiveness if they are paid during the covered period? And the answer to that question is now definitively yes. We've sort of kind of speculated on that and danced around it, but now it makes it very clear that as long as you don't push somebody's compensation over $100,000 on an annualized basis, there's still that $100,000 cap that's been there from the beginning. But as long as what you're doing doesn't do that and it's reasonable under the circumstances, then if you want to give hazard pay, if you want to compensate furloughed employees who aren't really doing any work, if you want to pay bonuses, those would all be eligible payroll costs that would be that you could put into your calculation for loan forgiveness. As for non-payroll costs, mortgage interest, rent, utilities, loan forgiveness is going to be, and I'm going to read this, loan forgiveness will be available with respect to amounts paid during the covered period. So if you make a payment of mortgage interest, rent, or utilities during the covered period, or with respect to amounts incurred during the covered period and paid during the next regular billing cycle, even if that is after the covered period, those expenses would be eligible for your forgiveness calculation. So you've got more flexibility on those types of non-payroll costs as well. Again, capturing that whole paid, incurred, and what they've done is interpreted it broadly so that you can use it the broadest way you possibly could. There was, and within that section, there was a number of Q&As, and one that I thought was interesting, and it says, if a borrower receives an invoice for an eligible expense during the covered period for expenses not during the covered period, but it's paid during the covered period, is it going to be eligible for forgiveness? And the answer to that question is yes. So if you get, so for example, if you had, if you received an invoice during your covered period for work or for an eligible expense that happened 2 months ago, but you paid it during the covered period, you'd be able to include that as well. So like I said, there's a whole theme going on here where the SBA has certainly decided to interpret all of this stuff broadly. Okay, the next change, again, to our benefit, is that talking about mortgage interest. Okay, mortgage interest, you're still not allowed to prepay mortgage interest. You have to pay it within the paid or incurred cycle. You can't say, I'm going to pay my mortgage interest for the rest of the year and then count it all. It has to be within the cycle. But they have more broadly interpreted your mortgage obligations. And what the SBA is now saying is that a mortgage obligation is any debt incurred in the ordinary course of your business that is a liability to the borrower and is secured by a lien on real or personal property and that occurred after February of 2020. So if you have, it appears that what that means is that you can include interest on any secured obligation. So it doesn't need to be a real estate mortgage. If you have a commercial loan that is secured by real or personal property, the interest on that loan you can now include in this forgiveness calculation. Okay.
Yeah, a couple more questions have popped up.
Okay.
At a point. So here's one question. If we switch to the 16-week period, we could exhaust our PPP entirely with straight payroll. That would simplify reporting somewhat. Does that seem like a good strategy, or is there some other downside?
No, if you can use it all for, payroll, that's, if that's the easiest way for you to do it and you exhaust the funds and get full reimbursement or full forgiveness, then I would say take that strategy.
Sounds a lot easier.
Yeah.
And another question. Can we pay a certain employee for additional hours during the covered period? For example, 20 hours per week versus 10 hours per week from the previous year? Can you increase someone's hours? Okay.
Sure. Again, when you get into the PPP, that 11-page PPP loan forgiveness application, you're in terms of calculating that forgiveness amount and whether or not that forgiveness would be reduced. The reduction area that you're talking about would be in the FTE, and they're really just counting full-time hours there. They're not looking at people. Anything else, Jessica?
That's it for now. Thank you.
Okay, so the final part of these new regulations that came out is that they have made that the SBA has delegated to the individual lenders the authority to approve or reject your loan forgiveness calculations. So it, again, as we've kind of reiterated, SBA is certainly going to look at what big borrowers have done in this program. The SBA and Treasury are very unlikely to look at what any of you folks have done. So the people who are going to take a look at this are going to be your individual lenders. And now the regulations specifically say that the lenders are going to be the gatekeepers. They're going to decide whether or not what you have applied for is in fact all eligible, or if some of it's not eligible. So I view that as good news, because obviously you have relationships with these lenders and they're going to be incentivized to help you out to the extent that you have. Also, if you have done something inappropriate, they're going to say no, as opposed to saying yes and then having the government be mad at you later on. So, but my big takeaway from that is I would, once you start to get into this process where you are seriously looking at your loan forgiveness applications, I'd reach out to your lender and say, this is what we're thinking, this is how it's going to work. I would get a feel for what they're thinking. And my guess is that some lenders will be more lenient and some more by the book. That's information that will be helpful to you, and you should try to sort that out sooner rather than later. So that's my 2-cent advice. So anyways, good news on the legislative and regulatory front. We've got the legislation moving through and hopefully signed soon that will extend us out to 6 weeks. I think that, or 16 weeks, I think that solves a lot of problems. And then obviously the guidelines are looking at these things broadly as well. The one thing that I just want, and I think it came up in the question, but I'm going to reference it. I have had a shocking number of questions about cell phones. I don't know, businesses have bigger cell phone expenses than I had anticipated. I swear to God, we've been doing this for a couple of months now, and 15% of the questions have been on cell phone expenses. And, and trying to be conservative because we haven't had real guidance, saying, well, probably stick to more traditional types of utilities. But there's certainly been some commentary that says, well, cell phones may be eligible, you can count it within phones. But, just looking at this and looking at how broadly the SBA is looking at the categories that we've been talking about these last 2 months, I think I've changed my mind, and especially since your lenders are going to be the gatekeepers here. If you have cell phone expenses and that's going to get you over the top, I'd throw them in. You just witnessed me changing my mind. Okay, we have some questions. If there's no questions, I'm going to jump in.
I do have one. There's one.
Okay.
This is not a cell phone question. Do we have to pay all our employees each pay period for 16 weeks? So we have employees covered by a grant, and we have the same FTE, but would want to pay only certain employees through the PPP program. In other words, can you fund some through a grant and some through PPE? Can you divide it up that way, I think is the question?
Absolutely, yes.
Great.
Yep. Of course, kind of keeping in mind, hopefully the 16 weeks gets you to and allows you to maximize your loan forgiveness. You don't want to, I guess my one caveat is you don't want to split up those expenses in such a way that you're not going to get your full loan forgiveness. But assuming that you're going to get loan forgiveness under your PPP and you want to use some other grant money, I think that's fine.
Thank you.
All right, how's my time here?
Oh,
good. I'm in good shape. Okay, are payments for leased equipment, copiers, printers, postage machines, those types of things forgivable? The answer to that question is yes. If you're paying lease payments for personal property, that would be included. Can we count employee contributions to retirement accounts in our PPP calculation? No, you cannot. You can count your employer contribution, but not the employee's contribution. Okay, this is, and I don't know if this is somebody new, but we have a question asking, what is a PPP and do we have to pay it back? If that's someone who's on the line, I'd say give me a call. We can talk about it more thoroughly. There's still time to do it, and there's still money available to do it. Once the Treasury cracked down on the big borrowers and closed the portals to the big banks, the flow of money slowed down significantly. But basically a PPP loan is a loan from the SBA to borrowers that is intended to be used by borrowers to bring their employees back to work and to pay certain other types of eligible expenses. If the money is used properly, up to 100% of the loan can be forgivable. I'm not going to go into it any more than that because I think most people here have been through this process and are sitting on their money. But if you have more questions on that, certainly give me a call and we will help you out. You can still apply for this up until the end of the month. Okay, I have a question. I want to know about more about accruals and can I accrue during my payroll? I think the answer, I think I've answered that now with the new regulations, but again, I'll just say that with respect to your payroll, when you apply for forgiveness, you elect whether to use what is called the covered period, capital C, capital P, covered period, or the alternative payroll covered period. And if you use the covered period, then you have, at this point, 8 weeks, maybe changing to 16, but at this point, 8 weeks to use those loan funds for eligible expenses, 75% of which have to be for payroll costs if you want to maximize your ability to get loan reimbursement. And then in addition to that, if you have anything other that was accrued in advance but paid during the covered period or accrued during the payroll period or during the covered period and paid later, you can do that. Can you give me an update on whether cell phones count? Yes, count them as utilities. Make someone say no. Have the previous guidelines changed since the last legislation? Yes, we went through that. We have obviously the new regulations that came out yesterday. And in addition to that, we're talking about some legislative changes as well. Are we allowed to include separation pay for employees that are no longer working with us? The answer to that question is yes. If you're paying separation pay, that is an eligible payroll expense, payroll cost under the regulations. Are we allowed to include interest on personal property? If the interest is, if you have financed personal property and you are paying interest that is secured by that personal property, you are allowed to include interest. Is Congress to expand the program? That is yes, I think it's at this point. Especially Senator Rubio said last, is likely to pass the Senate quickly, and I can't imagine the president wouldn't. All right, so that was my update, my good news update for the day. If we don't have any other questions, I'll hand it off to Sarah.
I see no other questions, so Sarah, please. Thank you, Jeff.
Thank you, Jeff. That was good. I'll try to save a little time in case any questions do arrive for Jeff at the end. I had a number of good questions arrive. I was calling out specifically for questions about reopening policies, and a lot of people have made good inquiries regarding what should be done, and I think amongst employers of all shapes and sizes, this is becoming an issue as people are not using their paid time off. And there's a real concern of both a loss if you have a use it or lose it policy, as well as a concern that everybody's going to have a rush to use it right before then. So we'll address both of those things. Where I want to start today are with some more general questions that have come specifically to me, and I have really good news that I got an actual response on some of them, which are work-share related. So let's start with the work-share first, because then I can kind of ease into more just general reopening, because work-share isn't applicable to everybody. But for those of you that are considering work-share plans, have work-share plans, there's understandably a lot of questions just because the program underwent many changes after the CARES Act, and the response to the CARES Act funding, as well as just a determination to make it a much easier barrier, to lower the barrier, I should say, to get in. So one of the questions, a really good question, was what is the protocol for if you have a work share plan and you have an employee who either quits or needs to be fired for a reason other than economic issues? It's not working out. And I was curious if that required an actual modification of the plan, which is what is required if you have substantive changes. However, it's a simple just emailing of the Department of Workforce Development at taxnet.dwd Wisconsin Gov, which is on the website under Workshare Plan, to provide both your plan number and the name of the individual that you want to remove. You don't have to submit a full modification application. So that's pretty simple and flexible. Another question that I had was, actually, I should say others have had, and I concur. There are a number of organizations that have academic year employees, 9 to 10 months out of the year. They do qualify. They are not exempt from workshare plans as if they were seasonal. So they are truly seen as, eligible employees. However, you want to be careful in terms of how you're adding them if you're not reducing hours. So there are some ways, depending on the circumstances, to incorporate them into a program too, if there's a need there. And I would just say, without getting into too much into the specifics, let me know if that's something that's coming up for you. And then my last question on workshare plans was just what if you have more hours that you can give to an employee? And my concern for the organization is just that you are operating within the spirit of the Workshare program, which is to continue to preserve at least one person's job, hopefully more. So you want to make sure that it doesn't start to appear like you pretended to have a program with 2 or 3 people and one of them is really working their regular hours. I would see that as problematic and you might get rejected. However, periodically, it is okay. Just have the employee report the hours that they're working, and do know that if they step outside of the 10 to 60% range, they may not be eligible for benefits. They may not be seen as truly being a participant in the plan that week. And I would imagine, I didn't get further clarification, but I would imagine if it is a regular thing, it might jeopardize their personal participation in the plan. So some good Workshare questions there. I'm really appreciative that the Department of Workforce Development was responsive to those. Then I had some other questions that I think it's a good way to segue into policies and reopening policies, because there's, as many organizations consider reopening, we have to think of the most daunting question, which is how to respond if someone in the workplace does contract COVID-19, or even there's a suspicion. So just as a reminder, one of the first things that I think the very first seminar that we had, the webinar that we had through this whole course, I spoke almost exclusively of the Families First Coronavirus Response Act, which there was a lot to take in at that time. And a lot of people were shuttering down to the point where it just wasn't useful. It wasn't something that people were using. So just do remember that is still available and something that you do need to provide for employees. And fortunately is something that it will be reimbursed and federally funded ultimately. So as you're thinking of pulling people in and you're trying to figure out what's that policy if someone has been exposed, or a person has tested positive, what you should do with everybody else in the workforce, and you know that somebody's going to be out of work, certainly first look to the Family First Coronavirus Response Act. If a follow-up question to that was good is if the person has a few days off because there's a suspicion, it takes a little while to get the test results back, and by then they've already used a week, and then maybe they find out that they have contracted it, they need even more time off. If you get past that point and they don't have sick leave and it's not possible for you to provide more, you could also look at them just being unemployed, them being out of work, not receiving wages, almost a furlough status until they're able to return to work. And they do currently qualify under that unusual federally funded unemployment insurance. It's very clear on the Department of Workforce Development's website that the PUA, the Pandemic Unemployment Assistance, does apply to people who are out of work for either of those reasons, because they have contracted it, or they need to self-quarantine at the advice of doctors, or because of exposure and its protocol. So it's good to know those two things are there. And then the other thing that I would say is think long and hard, particularly if, fortunately nobody is in this position, but if you are able to determine that it has been contracted at the workplace, I think that is a really good time to look at what options are available, and if you can provide as much paid leave as possible, even if it's outside your normal policies. So there we're shifting and we're turning a little bit towards policy. So I'm going to look at some of the questions I received specifically for today on reopening, and there's some real good ones here. The first question, interesting, was, is it acceptable to request all employees get tested before reopening? And this is like, I have much to say about this. First, it is actually permitted by the ADA. It is the results. You do have to have some care with how you handle that information. I can get into that further, but you can only imagine. However, there are less restrictions in the workplace in terms of the priority being that you're able to share information that people may have had a possible exposure. So you do need to weigh that in, is that you are taking in this privileged information. Some businesses have already done this, such as Amazon has been having people tested regularly. I know there's a lot of talk of the Major League Baseball is doing this, Las Vegas casinos. So it's mostly really big scale. But let's also remember that, especially if we're thinking about this just as let's get everybody tested before we go back to work, that could maybe make us feel confident for a day or two, but it is just a measure, it's a mark in a certain amount of time. And if you don't have real legitimate reasons to be testing on a regular basis, and maybe you do, I mean, you have to look at what kind of exposure your employees are having, and hopefully you're able to protect them enough that that's not something that outweighs all of the costs and also privacy issues, and just, I've heard the test is no fun. As you're weighing all of that, consider it in that you don't want to give a false sense of security. Instead, I will talk a little bit about what is being recommended. And I'll say one more thing about if you are in a position where you're requiring tests. You do need to pay all non-exempt employees, not only for the time that they're being tested, but also for the wait time. And that will also apply if you have any sort of like a temperature check in the morning. That part of the workday will be included. And that's what I'm shifting to next is what are maybe better things to do. And again, depending on what the level of exposure is, depending on people that are working with really small children, I feel like are at a much higher risk than maybe say a small office environment. The key things that all leading sources are saying to look to over and over again are focus on possible exposure, focus on symptoms, focus on travel or people in your household who have traveled or if they have had any symptoms. Taking temperatures has been something that's come up. There's some considerations you need to give if that's going to be something that you do. I absolutely don't want to plug it because I don't know anything about it other than I know that there's already an app that you can have employees use where you enter your temperature every day. If there's a lot of concern at your workplace and that's going to allay some fears, that's perhaps something to look into. We're gonna get to other things as we address returning fears that employees may have about returning to work. But just know that is out there. I think that covers all that I had in that area in terms of, how do we get everybody back in and how much testing is really appropriate. I had a question also about trying to follow state guidelines for the field, the industry that this organization is in, and then curiosity about how to mesh that with any conflict or overlap with local county guidelines. And as I said, the last time we met, when I just went over a broad overview with reopening policies, is if you can, I feel it's best to align with one authority. And I would put some preference on that being your local authority if they have something substantive. And I pointed to Forward Dane, if you are all in Dane County, as stepping up and doing a really thorough job of describing not only what the measures are going to be and how it works, but then weekly updating those metrics. And because those metrics are local, they're way more responsive and appropriate to be using. However, if you're in a locality that doesn't have that, or if maybe Forward Dane doesn't quite, or your county ordinance, whatever, doesn't really give you enough information, and perhaps anytime there's a conflict, you defer to one, and likely in this case, it would be the local, because that's going to be more, it's going to be more relevant to you, just based on geography. But certainly that doesn't mean you can't look to others for things that aren't spoken to or where you need more guidance. Let's see. Okay. Oh, I'm going to skip that one for now because that's better in the general policy question area. Do we need employees to sign something? It's a great question. Last week, I shared on the website, and it is listed under resources on our COVID-19 website, as well as there was a link to that page in our weekly update that announced this seminar on Monday. But either way, and certainly shoot me an email if you're having any trouble accessing or finding where it is on the site. I have 2 PDFs loaded, and one is a checklist of things to be considered, including links to signs, mostly from the CDC, that could be appropriate depending on your workplace. But also in there, I put a template for policy, and it's very bare bones. It's general, certainly everybody's going to need to massage it with things that are relevant to their particular workplace environment and activities. But in there, I had an acknowledgement on the bottom. And I really recommend that you do have some sort of an acknowledgement, or you have the employees attend a training and then have them sign into the training that you've gone through the policies, because you do want everybody to know you're taking this very seriously. And you do want some proof that there's been an acknowledgement. I do not, and other experts do not recommend any sort of a liability waiver for the employee. There's just, that typically isn't the best way. Courts don't perceive those very well in employment relationships. So acknowledgement of the policies, understanding the risk is good. And I think that, married with you having a good comprehensive policy that's really consistent in operations, is the very best that you can do at this point. I had a question before, I think I addressed it. There are other states that are giving some pretty heavy duty liability coverage to either essential businesses, and some are making it even wider than that. Wisconsin, I do not hear any peeps about that. And again, I really continue to believe that if you can, as much as you can, marry it to guidance that you're getting from a government authority, and I do recommend you review as much as you can, and you're following it, you're taking some great steps. Let's see. Oh, great question. Guidance for nonprofits who use co-working space when reopening. Yeah, there's a lot of offices that are split. I think that, much like when it was chaotic and we all had different self-quarantining rules around the country and around the state and whatnot, you need to get together and talk about it, and have pretty much uniform consistency with anything that's going to be. And I would think if you're sharing office space, depending on how closely, and how many shared quarters there are, you really need to be on the same page to make that work. So for that, you need to almost act in tandem. Let's see. Should parents sign a form that they believe, oh, this is a child care question for, if your organization works with children at all through programming or child care, should the parents sign a form that they believe their child and their family to be COVID-free daily? Man, I can really understand why. And while we can't get any, I haven't seen any authority say specifically do this or don't do this, there's a lot of recommendations for when you're working with children, especially children under the age of 12 or so, to do a daily temperature check. And also don't have the parents come into the facility. You pick up the children at staggered scheduled times outside of the facility, and maybe, sure, especially the first week, an interchange as the child is being dropped off of, is Jane feeling okay today? You know, no complaints of this and whatnot, making sure, because with kids, I mean, I don't know. I have kids, and I've erred both ways. I've kept healthy kids home, and I've sent kids to school not knowing either, because they didn't articulate. And I don't know that there's any way for them to know the seriousness of that. So I don't think you need like a signature every day, but a daily check-in until this becomes just so routine. Reminders in the weekly emails that go out reminding family members to be on hyper alert as to how their kids are feeling before they come in. Let's see. Final question in this. Oh no, I think we're switching over to more about just how, I'm going to check in with my time. Oh, I'm doing okay. I'm at 1:47. So then there are a lot of questions in terms of, as I had referred to earlier, a lot of PTO questions, paid time off questions. Right off the top, there's do our policies need to be revised due to, I think if policies are changing, yes, depending on to what extent. It may be a simple, we are currently modifying our handbook, call out the sections and list that this is going to be the modification until such time that, that we are living out, no longer trying to operate at limited capacity or whatever other tie-ins there may be. But then you can just remove that if you feel like this is a policy that is only going to change for the short time, so you're not making more work for yourselves. There may be other things where you really truly should be modifying your handbook. You don't feel like if you have a zillion other things going, that has to be the first thing you do. Most handbooks, I fortunately have yet to find one, even when they're not drafted by me, that there's a big disclaimer in the front. And if ever there was a time to pull on that disclaimer of that the employer can change these policies as needed, with or without notice, it's now. But the important thing is to know how you're going to change them. And it's really easy for me to say what these components have to be, way harder to actually implement them. And what they have to be is, or need to be, is they need to be, something that you can keep up with financially, something that's equitable, something that is, that's going to be consistent. You may have to release them, as you figure it out, that's certainly something that should garner some of your attention, and then formalize it later. But letting people know how you're modifying it, as soon as you can is the right thing to do. One question was on work share, or this would also apply to any organization that isn't reopening at 100%, even if you don't have a work share plan, is if the employees are working at a reduced percentage of what they normally work, should their PTO hours be accrued at that same percentage? And that right there is really an organizational choice. And again, based on those factors that I just mentioned, financially, maybe you need to do that. And also there's just the use. If somebody uses takes a week of vacation when they're only on at 50%, it can swing both ways, right? Where they're also going to get that week off and only be digging into half of it. I would make it consistent. I would make it fair, but ultimately something that your organization can sustain for a while. But a very good question, and something to think about, you know, if those are the choices your organization has had to make or will be making, is to switch around the hours, or the hours worked on a regular basis, to consider that. Yeah, I talked about this a little bit, but there's a good question here about how will daycare owners need to revise their policies. Gosh, there's not nearly enough guidance on this because it's a really tricky thing, especially when we're talking about younger kids. Right now, at least for here in Dane County, it's going to be groups of 15 kids that are not allowed to intermingle for at least phase 1 and 2. I think there will be a lot of policies that need to be revised. Everything from staggered start times to the temperature check I mentioned before, to maybe even dots that kids need to learn how to stand on when they're at the play table together. I'm sure it's not going to be 100% perfect, but you're going to make policies that have some, you know, that you will strive to meet as much as possible. And there's going to need to be some disclaimers to parents, and maybe in a more significant way than your typical visitor, but just letting them know that here, you know, these are the steps we're taking to keep this place safe. We appreciate you participating by making sure that your child is feeling good, and we're going to do a temperature check every day. You know, and things are going to have to change a little bit in terms of how and when you drop off. Also, I mean, if there's a group that maybe it does make sense to do periodic COVID tests, depending on how many kids and depending on the circumstances and how young those kids are, that might be the time. Everybody's a case-by-case basis. And then my last question here is, can and should you use, oh, this is good because this kind of ties in back. I'm going to give you Jeff a heads up, Jeff. This is swinging it back to you a little bit. Can and should you use the PPP loan to pay off PTO accrual? And I would say, and maybe you'll counter me because you've had all this new information, but I would say probably only if it's in response to a trigger based on policy or past practice that is occurring within the time that you are looking at for loan forgiveness.
Yeah, I'd agree with that.
Yeah. Okay. Okay. Then, yeah, just to give you some sense on those policies that we talked about, I read something that I think was dated from a week ago that said 42% of organizations that have been polled, these are probably larger, more for-profits, but just to kind of get a sense, have made changes or making changes now to their PTO policies. 24% are increasing their carryover limits. 16% are instead requiring use of PTO in a certain amount of time, so they're not allowing for further carryover. What advice I would give to everyone that has this, if they don't know what they're going to do yet, is at least to remind employees of their accrued vacation days. There's been so much that's happened and our lives have been turned upside down so much. It's worthwhile to, even if you don't know how you're going to deal with it yet, to just give everybody a reminder of that. A lot of people could probably use a break even if they can't go someplace or any place really, but could use some time off. I have a little bit of an update on what I touched on last time regarding the OSHA notifications. If you are able to determine that you have, and I don't have the language in front of me, but if it is, if there's a case of COVID-19 that can be traced as being workplace spread. They are now saying that this will need to be reported on a Form 300, and the recommendations are that organizations do a small amount of investigation if they have an employee that tests positive, which I think makes sense anyway, that you would want to rule out. You likely want to have policies that definitely allow for the cleaning of the workplace if it's if the person's been on site recently, alerting all other staff, recommendations to self-quarantine until they're tested, and to be really on high alert. So yeah, so that's Form 300. There is some extra guidance, but it's not, I'm not the only one who's felt like it's not been super helpful so far. Let me see. It's odd how there's a real lack of attention to child daycare services, how that would be addressed. Oh, sorry, there's one other update I knew there was. They are stepping back from it being a requirement for all organizations and instead saying that if you have 10 or less employees, which I know that is a lot of our group, you're exempt from the reporting. Yeah. Then last would be just I've had a lot of questions about people having fear upon returning, employees having fear. And we talked about that last time as well, which is understandable. I believe we've talked, and in my materials, all the things you want to be doing, from screening employees and all the visitors, to make sure there's a sign at the door, or if necessary, a temperature taken, social distancing, offering PPE, reviewing the cleaning techniques, both either with your landlord, janitor, or just inside your office. And offering flex time from home. Aside from that, explaining to people, why your needs as an organization to have people come in, and being very careful that if you have different policies on who has to come into the workplace and who doesn't, that you've got legitimate business reasons for it. Just a general fear of going back to the workplace isn't truly protected. However, I'm sure all of you will be very sympathetic if people are concerned, and help them look for options in terms of if it's more than just a generalized fear, then maybe some reasonable accommodations can be made. All right. Any other questions?
There are none in the chat.
All right. Very good. These were great questions. Thanks everybody for submitting them.
And certainly, I think I'm speaking for Sarah. If people have follow-up questions, feel free to ring us, send us emails. We're pretty responsive in getting back to those.
Okay. And one just came for you, Jeff.
What?
A new question just popped up for you.
Okay.
Here we go. Our PPP 8 weeks is almost up. We've been approved a work-share program to begin at end of PPP. Hours are being reduced by 60%. Will this affect our FTE calculation and forgiveness if the PPP cover period is extended for another 8 weeks for payrolls at reduced hours?
So let me talk back the question to make sure I understand it. So we've got the 8-week covered period that we're in now, and there's an anticipation that there will be a reduction after that.
I think so.
And so the question is, if the covered period expands from 8 to 16 weeks, will that affect the FTE calculations?
That's what
it will. Yes, it will. But it also, just the way math works, but because you're paying on a longer period, it's still, your forgiveness amount still may be increased, even if you do a reduction in your FTE for that second 8 weeks.
Right. And I think it's being reduced by 60% rather than to 60%. So even though it's twice as long, it still wouldn't be quite as much if it's being reduced by 60%. So it would be a little bit less. So, okay. Great. With no more questions, as always, if you do have more questions that you come up as soon as we leave the meeting, please send an email or to Jeff or to Sarah. And also a reminder that we will be updating the Q&A on our website, so you can check that out. Try to keep that current for you all. And again, wanted to just say thank you to Madison Community Foundation for continuing us being able to help you all. And Jeff and Sarah, anything else that we need to get in there?
Yep. No, just that we continue to update the Q&A and the blogs.
Yes.
Yep. Great.
For sure.
All right, everyone, thank you so much for attending, and thank you so much, Jeff and Sarah, for your knowledge and sharing it so clearly. Appreciate it.
Thanks.
Bye-bye.